Wet reckless in Marin County would typically be punished less severely than a regular DUI, which is why a lot of people will take that as a disposition on their case instead of going to a jury trial if we can get the case negotiated down to a wet reckless. The big difference between the two is the length of probation. A regular DUI is a 3-year probation, where a wet reckless is only a 1-year probation. That's really important because as soon as that probation is over and you've successfully completed it, which basically means you've paid your fines and not got any new offenses or violated your probation in any way, and you've completed any DUI school that you have to do or anything else, then you can get it expunged and have your attorney bring a motion to get the court to dismiss the case so that your record shows that the case would be dismissed. The other penalties are typically a 12-hour DUI class, but if you are not, or your attorney is not able to win the hearing with the DMV, if you want to get a restricted license instead of suffer a suspension, a minimum of 4-month suspension, if you got the wet reckless in court, you have to be enrolled in a 3-month DUI school. So if we can win the DMV hearing and if we get a wet reckless in court, that's fantastic. You can do the 12-hour DUI school, and that's all you'll have to do. It's cheaper than the regular DUI school, the 3-month one, because the 3-month one costs $700. The wet reckless school is a lot less. And also it's nice to be able to avoid the suspended license or getting that restricted license, because to get the restricted license, you either have to go, if you have a wet reckless in court and don't win your DMV hearing, you have to go 1 month of no driving followed by 6 months of work-restricted driving, just to and from work and work-related driving, or you can go right into an ignition interlock device, which you would need to have for 4 months. And we can actually get that for clients much quicker. We don't have to wait that 1 month of no driving. And that's something that an experienced DUI lawyer in Marin County will be able to help you with, walking you through that, timing it so that you're not down without a license, without a car for, many days or weeks or months. And that happens all the time. I get calls from people all the time who either had a public defender or who had an attorney from either another county or someone who's not really experienced with DUI cases and just does general criminal defense, and did not walk them through step by step how to get that work restricted or ignition interlock license. And the great thing about an ignition interlock license, also called an IID, is that allows you to drive anywhere, anytime, go wherever you want. There's no restrictions on it other than you can only drive a vehicle that has an ignition, a properly functioning ignition interlock vehicle in it. The other thing about a private attorney, an experienced DUI lawyer, is that we can point you in the right direction for, things like companies that have very good reputations, very good customer service for things like additional insurance you need in order to get your license reinstated fully or even on a restricted basis. And also, the companies that aren't going to mess up when they're installing the ignition interlock devices. A lot of times those companies have issues with the paperwork. They're not real local companies, and this has caused a lot of problem for a lot of people. So we try and make this whole procedure as smooth as possible for our clients from beginning to end. And, you really want to get someone who's experienced helping you out. And there's just so many different reasons, many that I haven't even come close to going into, and many that you can find looking at other videos that we've put out, or we always do a free consultation for anyone who's been arrested for a DUI.